The Open Meetings Act is your school board making mistakes. Hey everyone, it's OSBA Senior Communication Manager Scott Gerfen. Thanks for joining the Leading the Way podcast, brought to you by our new sponsor, Pappas and Associates, shaping policy with integrity. Well, joining me today is OSBA Staff Attorney John Price, and we're going to dive into the crucial topic of the Open Meetings Act. And before we get to John, I want to let you know that registration is open for the 2024 OSBA Capital Conference and Trade Show. It's November 10th through the 12th, and we have a brand new conference website this year. It's conference.ohioschoolboards.org. Be sure to get to that site, and you'll see why you don't want to miss Ohio's premier education event at the Greater Columbus Convention Center. John, thanks again for coming on the podcast.
Thanks, Scott, for having me. I always enjoy being on here.
First up, I have a question. If three school board members, decide to go, say, out to breakfast to their favorite dining spot in the district, is that a violation of the Open Meetings Act, or as it's known, the Sunshine Law?
That's a great question, Scott. It certainly could be. So once those board members who are having breakfast start talking about the public business of the board, then that starts to very much look like what the Open Meetings Act would define as a meeting. And we can talk a little bit more about that specific definition. So yes, it's very much potentially a violation once they start veering into the territory of discussing the public business of the board.
And this could come up in a number of different scenarios, like, say, if they're in a text chain or a group chat on Facebook. These are all instances that could violate the Open Meetings Act, right?
That's exactly right. So the Open Meetings Act has a specific definition for the word meeting. It's not just whatever the board calls a meeting. So a meeting under the Open Meetings Act is any prearranged discussion by a majority of the board's members of the public business of the board or other public body. We're talking about school boards here, but it applies to other ones as well. And there is case law out there making it very clear that this does not just apply to in-person meetings. It applies to virtual meetings, phone meetings, and critically, where it's very easy to make a mistake is text chains, Facebook messaging chains, Facebook comments. Those are all places to where board members can very easily step into talking about the public business of the board, which would cause a problem.
So I can see where that might, trip up some board members. But, what about the committees and subcommittees? We hear, some boards have these as well. Are they subject to the Open Meetings Act?
Right, Scott. And this is a question that we get a lot here at OSBA. I think I understand why we get questions, because it can be a little bit of a tricky area. So committees and subcommittees of the board are considered public bodies for the purposes of the Open Meetings Act if they are what we call committees of the board. And unfortunately, there's not one surefire way that we can use to tell if a committee is a committee of the board. Typically, the rule of thumb that we use is if the board is creating the committee and nominating individuals to that committee, like, say, what often happens at the organizational meeting where they say, we're going to put these people on the finance committee, for instance. Those are almost certainly committees of the board that are going to be subject to the Open Meetings Act. Other committees, like, say, committees that are more internal to the district that are created maybe by the superintendent, those in many cases might not be committees of the board because they are not created by the actual board members. Right. However, even in those situations, sometimes depending on what that body is doing, it can venture into that territory. So it is a tricky area, but it's something that our members need to be really careful about.
So what if you have a booster committee that may not be subject, because that may not be an official committee of the board?
Potentially not, particularly if the booster group is separate from the school district, which is, of course, a topic kind of outside of what we're talking about. But but yes, potentially not. But always, if there are questions about that is something to run past your legal counsel or even give us a call.
And that makes sense. So far, we covered informal gatherings and committees. You've hinted at another big issue regarding executive sessions. Can you elaborate on executive sessions?
Sure. I can't believe we made it this far into this conversation without talking about executive session, because it's probably the single most common Open Meetings Act issue that we get on our hotline. But executive session, for those who may not know, is an exception to the general requirement that public bodies have their meetings open to the public. So how it basically works is there are very specific provisions in the Open Meetings Act in 121.22 of the Ohio Revised Code that allow school boards and other public bodies to go behind closed door to have deliberations, critically not voting, about certain topics. And we certainly see boards have issues with this all the time.
And so there have to be specific reasons to go into executive session, right? And I mean, you have to, there's a list of reasons. You can't just say, I'm going into an executive session.
That's exactly right. So there are very specific reasons listed in the statute. The board is going to serve itself very well by being very specific in its motions to go into executive session, very much clearly identifying what they are going into executive session to discuss. So, picking out that topic or topics, because there are many situations to where a board will go into executive session to discuss more than one topic that is appropriate. But what they need to make sure they're doing is that they're properly identifying that topic, and once they get into executive session, sticking very clearly to those topics that they went into executive session to discuss.
And I know the legal division has a fact sheet on this, and we're going to talk about it. We'll make sure we put some of those resources in our show notes as well, because we're going to discuss some, because we have a bunch of resources.
Yes.
You guys have a ton of fact sheets on these topics that are very helpful. I want to talk about the consequences. Let's say a board violates the Open Meetings Act, does not comply. What happens?
So there are a number of consequences that can happen when a board violates the Open Meetings Act, none of which are anything that we want our members to have to go through. First and foremost is there's a high chance that they could have litigation on their hands. And that is, regardless of how that might ultimately come out, that is obviously very unpleasant and costly for the school district. And many of our members will probably know that there are individuals out there right now who are very much specifically looking for these issues. And these are not individuals, by the way, that have to live within your school district. These can be people who live outside the school district that, if they can identify some of these mistakes, can cause an issue. Also, a really critical consequence that can happen, particularly if someone does challenge what happens under an action taken in violation of the Open Meetings Act, is a court can completely set aside an action that the school board has taken that in some way involves a violation of the Open Meetings Act. That's obviously potentially opens up a huge can of worms for the district, and we don't want to see that happen. So it's really, really, really important that the district make sure it's dotting its I's and crossing its T's on this topic.
Yeah, it sounds like a lot is at stake. I mean,
Certainly, absolutely.
I discussed resources in terms of executive sessions. What other resources would you recommend? We have a ton of fact sheets, I know.
Absolutely. The first place I would start is on OSBA's website, which I think you mentioned. We can put a link in the episode description for. So I would certainly start there. We also do a number of trainings on this topic in school districts. We talk about this at Board Member 101 and 201 and all of those. I also want to plug, you did mention Capitol Conference earlier. We mentioned 3 of the mistakes that we see commonly on this topic. If you want to hear 7 more mistakes that boards often make in this area and a couple other related areas, my colleague Jenny Harden and I are going to be doing a session at Capitol Conference where we're going to really get into this in more depth. So we would encourage people to come to conference and come to that session specifically.
Right, and that's a good point to make, because there are going to be a lot of legal sessions that people can pick from when they attend the Capitol Conference. John, thanks for sharing your insights today. Anything else you want to share with our listeners?
No, I said no, but I will say yes. I would just say be really, really careful about this issue. I mean, I said this already, but this is something that we are seeing a lot about right now. And, some of it can seem very technical and very kind of confusing, but don't let that stop you from being diligent, asking questions. It's much easier if you give someone like our hotline a call or talk to your legal counsel if you have any sort of doubts versus dealing with some of these consequences after the fact.
And the legal hotline is
855 OSBA Law.
Yeah, and we'll end with that. And thanks again to our new sponsor, Pappas and Associates. They're shaping policy with integrity.